Good morning. Can everyone hear me?
Yes, ma'am.
Yes, Your Honor.
Okay, good morning. I'm Jamie Grosshands. Welcome to today's session of the 5th District Court of Appeal. I have with me today Judge Traver and Judge Harris. I just remind the attorneys that we are broadcasting live and it is recorded. Today's session will be recorded and available on YouTube. Can both of you see the clock?
Yes, Your Honor.
Yes, Your Honor.
Okay, we'll reserve 5 minutes for the appellant for rebuttal. If you'd like something different, please just let us know and we will go ahead and get started. This is 19-1567, which is Law Offices of Archibald Thomas and Vicki Graves versus the Insurance Office of Raymond Strickland Jr. Inc. et al.
Thank you, Your Honor. And 5 minutes will be just fine. And may it please the court. My name is Ron Angerer, and I'm appearing today on behalf of the appellants, the Law Offices of Archibald J. Thomas III, PA, and Miss Vicki Graves. The reason that we're here today is that in the proceedings below, the appellants were sanctioned by the trial court for having filed 3 separate motions: a motion to dismiss the second amended complaint filed by the Appellee Insurance Office of Raymond N. Strickland Jr., which I will hereafter just refer to as Strickland, filing a motion for leave to file an answer and counterclaims to that same pleading, and a motion for reconsideration of a prior order entered by the trial court, finding that Ms. Graves had engaged in fraud in the court and entering a default against her. The question presented that arises out of that decision by the trial court to sua sponte sanction the appellants is whether or not the trial court, without having provided the appellants notice or an opportunity to be heard regarding its concerns, abused its discretion when it sua sponte sanctioned the appellants under section 57-105(1)(a) and B.
Counsel, I'm
yes.
going to ask you about this argument about notice and opportunity to be heard. What do you think she sanctioned the parties for at this point?
Well, Your Honor, the best I can tell from the order entered by the court is that with respect to the motion to dismiss and the motion for leave, the trial court sanctioned the appellants for having engaged in, as worded in the order, impermissible relitigation, which I understand to mean essentially that, as stated by the court, any further efforts to address any issue relating to the default or the sanctions was futile and it should not have been attempted. That was also a reason that the court sanctioned the appellants for having filed the motion for reconsideration. However, in addition to that, with respect to the motion for reconsideration, the trial court also noted that the motion for reconsideration was not proper under the federal standard for seeking reconsideration. Now, in addition to that, there is some vague and, in our opinion, ambiguous language in the trial court's order about having not simply adopted the motions filed by Strickland, and that sought sanctions. As the trial court,
your argument that she sanctioned the parties for something other than what she listed on page 12 of her order under findings, which was they were not supported by material facts necessary to establish the claim or defense, or were not supported by the application of then existing law to those material facts. The filings of these motions caused unnecessary litigation and delay of the proceedings. Do you think there was something additional she was sanctioning for?
Honor, he appears to be frozen, and at least from my screen, he appears to be frozen and not transmitting.
We'll give him a second to see if he comes back online.
Yeah, his backup too is to just call the conference number that was provided as a backup and dial in.
Can we stop the clock? Thank you.
Hello?
Hello, counsel. Do we have you back?
Yes, you do.
Okay, we did stop the clock. And so I don't know how much of my question you heard. So I'm going to ask it again, but I'm going to ask the marshal to not start the clock until I finish my question.
I can't hear you, Your Honor.
Can you hear me?
I can hear you, Judge Traver. I can't hear Judge Roshan.
Anything else that she was sanctioning for? Is it your contention that there was something else?
Amy, we couldn't hear that question.
Okay.
Judge Grosshans, could you do that just one more time? I think I'm really excited about our audio capabilities right now.
Okay. All right. Is that better?
I can
Yes,
hear you,
ma'am.
Your Honor.
Okay. On page 12 of the order, the trial court listed the reasons for the sanctions, which was she found there were no material facts to support the motions, and they caused unnecessary litigation and delay of the proceedings. Is it your contention that she sanctioned for something other than that? Was there additional reason for the sanctions?
No, Your Honor, I don't dispute that the trial court proceeded under Section 50, or the appellants don't dispute that the trial court proceeded under Section 57105 1A and B. Our contention with respect to that particular lack of notice is the ambiguous assertion by the trial court on page 11 of its order, where it states that it's important to state that this court is acting on its own initiative, and the decision herein is based upon the court's familiarity with the case and its review of the record. The court is not simply adopting the reasons set forth in the plaintiff's motions for sanctions. And our contention of why that is an ambiguous statement by the trial court is that its description of Strickland's motions is identical to its stated reason on page 10 for why it is sanctioning the appellants under Section 57105 1A and B. But more fundamentally than that, Your Honor, the trial court simply gave no notice that it was proceeding on its own initiative under 57105 1A and B until it acted. And it is our contention, Your Honor, that that is clear error under the recent fourth DCA case of George versus Gilbert.
Well, that case hadn't been decided, correct, at this time?
That is correct, Your Honor.
And what notice would have, what type of notice would you have wanted?
So, Your Honor, I think there's a little bit of legal background here that might make answering this question easier, or help the court in answering this question for itself. And those cases are Koch and Watson. And in each of those cases, the question presented to the appellate court regarding notice was whether or not the trial court was bound to follow the 21-day notice requirement detailed in Section 57105. And in each of those cases, the district courts of appeal said no. And this court in Alexander, when it remanded a proceeding back to the trial court and suggested to the trial court that sanctions may be appropriate, adopted the reasoning of Koch. Now, what is interesting about Koch and Watson is that in each of those cases, while the trial court proceeded on its own initiative, it had previously given to the litigants in those cases notice that it was considering proceeding under its own initiative. It had told the litigants, I would like a memorandum, or I would like you to respond to my concerns that sanctions may be appropriate.
Counsel, are you saying, I apologize, the telephone thing isn't elegant, and I apologize for talking over you, but are you saying that you needed pre-hearing notice or notice during the hearing would have been sufficient?
Your Honor, I think that had the trial court at the hearing said, I'm considering doing this on my own, these are my concerns, please respond to them, we think that that would have been sufficient. We think that reasonable notice is what is required. And
Can I
here,
take
no
you back a
notice.
little bit to Judge Grosshands' earlier question about the form of the order and what the trial court's findings were? Do I understand it to be your contention that the trial court outlined all of the reasons that you think that you were sanctioned? Or do you think that there was something else that's mysterious that was not disclosed?
Well, Your Honor, it's our contention that the fundamental, we don't dispute that the trial court made clear that it was proceeding under section 57-105-1, A and B.
I guess I'm not talking so much about the legal basis because it's clear what the statute was. I'm talking about the factual basis, the application of 57-105 to the facts of y'all's case.
Yes, Your Honor, it would be our contention that the trial court's assertion of not simply adopting Strickland's motions without making clear what parts it's adopting or not adopting, and its description of Strickland's motion versus and how that's identical to its description of why it was sanctioning the appellants creates an ambiguity. It may be that the trial court had no other reasons, but I don't think it's possible to discern that based on the ambiguity of the assertion made by the trial court in its order. And it's our contention that that is inconsistent with myriad cases arising under 57-105, detailing what needs to go into an order.
Do you believe that the reasons that were outlined by the trial court were new and different motions or ones that were contained in the movement's motion?
As far as the reasons that are unambiguously and expressly stated in the order, as I understand it, they are like the arguments that Strickland made in its motion, namely that it assessed the merits of our motions against its own prior rulings and determined that because it had previously ruled in Strickland's favor, we should have known not to make a similar argument again. That Strickland argued that below. The trial court sanctioned us for that reason. In part, the motion for reconsideration was also sanctioned because it was impermissible under federal law, which I think Strickland had made an argument that the motion for reconsideration was frivolous for not having asserted any new law or fact. But our contention with respect to that is that that was erroneous because the federal standard is materially different.
Do you concede that you're in a district that would allow a trial judge to adopt the rationale of a movement that for some reason was procedurally deficient?
Yes, Your Honor.
So if that's the case, and the judge made findings, and maybe she made an inaccurate assumption that she needed to adopt different reasons, aren't the basic findings in that order enough to affirm under the law of the district?
If I understand your question correctly, Your Honor, is it that your question is that if there are some reasons that are sufficient to affirm, but other unstated reasons exist, can the appellate court still affirm?
Let me rephrase it in a different way. That's essentially the gist of it, but let me rephrase it in a different way. Let's say that instead of saying, I'm not simply relying or adopting the reasons that are set forth in the motions. I am just adopting the reasons set forth in the motions. Do you have a due process argument at that point?
So, Your Honor, that by itself is permitted, as I understand it, in the 50CA. However, the cases that have addressed that have not addressed whether or not the trial court can do that without giving the parties an opportunity to respond. We would contend that even if the trial court was just doing exactly what the appellants had or what Strickland had argued, or one of the parties had argued, if it adopted a procedurally defective motion or a perfectly fine motion, procedurally
But
speaking.
where's the harm in that, Mr. Angerer? If you're apprised by virtue of the motion that's filed against you, you go to court that specific day knowing precisely what's going to be argued. And then the trial judge says, I'm sanctioning you for precisely what you were on notice to potentially be sanctioned about. Where's the due process issue of that? Is it just the magic words of, I'm doing this on my own?
Well, Your Honor, we would contend in this case that the error was not harmless. First, there is the ambiguity of its assertion that there could be other reasons, and we think that we have a right to respond to those reasons. Second, we think that it is a different type of action in kind when a trial court says on its own that it's considering sanctions. We would respectfully submit that that's a far more serious decision, and that in this instance it could have avoided potentially a back and forth appeal, because we contend in this instance that the record does not support sanctions, and that there were findings made by the trial court which we contend required an evidentiary hearing. And so we think that this due process consideration applies equally to a trial court in the event that a party wishes to apprise that court that an evidentiary hearing is required that avoids back and forth appeals and multiplication of the proceedings, and to specifically address head on the concerns of the trial court. We think due process applies equally to the trial court. But as I was saying earlier, we would respectfully submit to this court that in answering the question presented, that the trial court did abuse its discretion in sanctioning the appellants, because, put simply, the conduct for which the appellants were sanctioned was entirely permissible and warranted under federal law. This is underscored by the fact that neither the trial court nor Strickland, either below or on appeal, has been able to identify a single case or law to support the notion that the appellants did anything wrong, or were even wrong in their arguments. Now, while we're not here on appeal to decide whether or not the trial court should have granted our motions, we think that that is a significant fact, that there's no case that's been cited or law that's been cited by Strickland, either below or on appeal, that says we're even wrong.
Is one possible reason for that is that nobody has ever done what you all did before? I mean, your client was defaulted as a sanction, and then you attempted to inject yourself back into the case after you were defaulted as a sanction. I can't imagine that there'd be a grand breadth of appellate case law on that. I certainly wasn't able to find anything.
So yes, Your Honor, in that regard, with respect to, well, there's a couple things. There's a plethora of case law that says that you can file a motion to dismiss when a new operative pleading is filed, even if there's a default. You can file a motion to dismiss
As a sanction?
Yes, I mean, I don't know a case specifically that says that, but certainly the court can't sanction a party by putting them at liability for a claim that fails to state one.
Well, I mean, that might be a damage issue. You know, the case that you cited in your reply brief, that Bear Board case, seemed to suggest that you'd be able to make a presentation either at a hearing or at a trial about causality between the claim for relief and damages that the plaintiff might have actually incurred. But that doesn't necessarily mean you can inject yourself back into a game after you've been kicked out of it.
Well, Your Honor, I think that at least with respect to the motion to dismiss, it's just a fundamental due process failing that a party cannot get relief on a claim that fails to state one. And I don't think the court can award relief as a sanction for that reason. And in here they amend it, and the rules of civil procedure and the cases cited in our briefing support the fact that we could have filed a motion to dismiss. As it relates to the motion for leave, that was based on a novel argument, and I would submit to the court that it's an extraordinary remedy to sanction a party in this manner. And it's probably even are nearly just as unusual for a party to amend after it's secured a default.
Counsel, you have about a little over 2.5 minutes left for your rebuttal. Do you want to reserve the rest of the time?
Yes, Your Honor. Yes, Your Honor. Yes.
All right, thank you.
Free to proceed, Your Honor.
Yes, you may. Thank you.
Thank you. Please the court. Patrick Gilligan, I represent the insurance office of Ray Strickland, and I too will refer to it as Strickland. My client sells health insurance to employers, group health insurance. He employed the appellant, Mrs. Graves, for a number of years before she decided to leave his employment. She was well compensated. I think her last year was about $170,000. When she left, there was a little evidence that she had violated her duty of loyalty and her confidentiality agreement, non-solicitation agreements with my client to not solicit the clients of Strickland. The evidence of that were a couple of agent of records or AOR letters. They're like one-page documents. It's simply direct carrier like Blue Cross Blue Shield as to who to pay commissions to. They got AORs that were dated prior to her leaving Strickland's employment while he was paying her. That caused them to be suspicious. Ultimately, filed a 7-count lawsuit against Ms. Graves, all centered on her lack of loyalty, her solicitation of clients, a non-compete, things like that. Of those, count 2 is a breach of contract agreement based on an employee handbook that does state it's not intended to be a contract. That employee handbook, however, was amended by Ms. Graves, and she initialed it. My client agreed to it and said that if she left with any clients that she had procured herself while at Strickland, she reserved the right to take them. So we believed it. Yes, ma'am.
Counsel, could I interrupt you just for a minute and ask you about two kind of specific things? First, do you find that this order that the trial court is there any ambiguity, I should ask, about why the trial court sanctioned in this case under this order?
Thank you, Your Honor. None in my mind, obviously, but I'll support why I obviously think that. She made very detailed findings of fact about what Ms. Graves had done. I think there were 7 in our brief that we detailed of what she actually did. And it all came down to her being a vague and invasive in her responses, claiming that records she had were not in her possession, false testimony about when she began working for IOA, false testimony by why she waited until October 2016 to leave, to officially tell Strickland she was leaving, false testimony about providing IOA's Strickland's client list to IOA. By the way, she did that via email on her private email account on numerous occasions, which the judge noted, and she had denied ever doing that in her 3 depositions.
In specific, this order, I guess it would be the second order on sanctions, the one that we're more focused on today. Do you find there's any ambiguity there in why the trial court sanctioned?
No, I don't. And I also would point out to this court that Ms. Graves, and this is part of the appellant's argument, was deposed on 3 occasions. The first occasion was, and I think the trial court noted this, was to bring Deuces Takem to her deposition email. She brought in 90 some odd emails from her Strickland email account, 2 from her private account that advanced her theory of the case. It wasn't until we discovered through IOA discovery that she had a bunch of emails that were contrary to what she had said. She was deposed a second time, given an opportunity to explain that. She did not. We then filed the motion for sanctions. She was asked at a 3rd deposition, had she seen the motion for sanctions? She said she did. And so then we get to the sanctions hearing, which is an evidentiary hearing. She was examined by her own attorney, Mr. Green at the time. Mr. Anger is her 3rd attorney. She was examined by her attorney, Mr. Tripp Green. She was cross-examined by me. And she was also examined by the trial judge, Judge Lisa Herndon. She had ample opportunity to persuade the judge that everything we were saying about her was unfounded, or there was a good reason for it, or whatever. She failed to persuade Judge Herndon. So after the sanction order gets entered, and I think this is probably one of the most telling pieces of evidence, her former attorney files 2 motions after the sanctions order entered. The first motion is saying that she's given consideration to what's happened to her because of the sanction order. And for the first time ever, she says, I, on my own, did research about 2 drugs I was taking, Wellbutrin and I think Activan. She files her own affidavit in support of the motion saying, I found out now that those 2 drugs cause memory loss. And so therefore I have an excuse. What's notable about that motion is she's not saying what Judge Herndon found was incorrect. She's saying, I think explicitly, but at the very least implicitly acknowledging that what Judge Herndon found was correct. All the findings of fact were correct. She's saying, I have an excuse. I have a medical excuse that I've taken these drugs. The appellants never, ever, not on their motion for reconsideration, and not in this appeal, ever take into account that, I think, very damning first motion for reconsideration. She then files a second motion for reconsideration with her previous lawyer. And this time, in addition to the Activan and Wellbutrin excuse, she says, I now just remembered that I accidentally deleted or lost all these emails after May 2nd of whatever year it was. Once again, explicitly or implicitly acknowledging what the trial court had found in their findings about her behavior. Now, Judge Herndon had an opportunity to weigh her truthfulness. She was on the stand. She was the trier of fact and also the judge there for that hearing. The appellants have never, ever dealt with that issue of her acknowledging, I think explicitly, that Judge Herndon's findings are absolutely factually correct. That's to me is undisputable at that point in time. Those things happened. They don't argue that they happen.
Let me ask you this. The reasons why the default was entered as a sanction aren't really part of this appeal, are they?
Well, yes,
We're more concerned
indirectly.
with the sanction for on the 57105 for filing these pleadings subsequent to that default. What, in your opinion, is the effect of the default that was entered in this case?
It would have defaulted her as to all 7 counts, and we had to go forward to prove damages as to those counts. We're not automatically entitled to our damages. We still have to prove those. And I think that's also a piece of evidentiary evidence in this case that's very telling. Let's say the appellant's correct about their ability to challenge count 2, the breach of contract. There's still 6 counts, all centering on the same factual issues for which it wouldn't have mattered. Okay, the judge says you're entitled to dismissal of count 2, the breach of contract, but it still leaves 6 counts. So that begs the question, to what end did that actually advance the appellant's position? She still defaulted on 6 others.
Well, that means she admits the allegations in that original complaint, right?
Yes, sir.
You've got another count here that talks about breach of the confidentiality agreement. You've changed in one of your pleadings what the terms of that confidentiality agreement are. I think in your most recent complaint, you say it includes the identity of the clients, each group health contact person, and the decision maker. That wasn't in the first pleading that she would have admitted by the default. Wouldn't she get a chance then to file some kind of response to that new allegation that materially changes the allegations in count 1, I think it was?
A little bit of a disadvantage here, Judge Harris, because I believe she was defaulted on the second or the amended complaint. We did make some corrections from the first complaint to the second complaint because counsel, the first lawyer, filed a motion to dismiss as to 3 counts, including count 2, the breach of contract. We believe that some of their objections as the other were well taken. We filed an amended complaint, and then they refiled their motion to dismiss, and those were denied explicitly as to count 2, which is this breach of contract complaint. So if what you're asking me is about changes from the first complaint to the amended complaint, I'm only focusing on what we had in our amended complaint. We did not make any substantive changes as to Ms. Graves when we filed the amended complaint, and we added Insurance Office of America and some of their employees.
Are you talking about the second amended complaint now?
I think it's the second amended complaint. We first sued just Miss Graves.
Right.
And then there was a motion to dismiss. Then we filed an amended complaint just as to Miss Graves. So I'm operating on that amended complaint. After the sanctions were entered, we filed a second amended complaint. We add additional defendants, IOA, and some employees of IOA. We make no substantive changes to those 7 counts as to Miss Graves. We identified her as Graves instead of defendant because now we have multiple defendants. But there was zero substantive changes. The appellant argues that because we made an amendment to the complaint, they essentially get an ollie income free. Nothing that happened to her, it all magically disappears. The trial judge rejected that. That the default stands as to them. That's what she ruled on, and that's what the record indicates.
But there's federal cases that would support that argument, right? That and a new amended complaint could void a default that was entered to the prior pleading.
If there are, I'm unaware of them.
Answer, but
I'm unaware of them, Your Honor. What we cited in our brief was a federal case that deals with reconsideration. I didn't see any federal cases. Certainly, I don't think they're in my brief. If they are, excuse me, I just don't remember them as we sit here. But what the appellants have been arguing is that the amended complaint essentially makes everything go away and they get a do-over. That would wreak, I believe, havoc on the system. As you know, plaintiffs have pretty liberal ability to amend their pleadings as they go along. You can't obviously do it right before trial, but you can with the court's consent. But really, you're allowed to amend your pleadings. If their position was well taken, anytime you got a default, a court default in this case, against a defendant for what happened, you would be in the predicament of, we now have evidence that additional defendants may be also liable here. And that's what we can't amend our pleadings because the defendant that has been defaulted, even though nothing substantively changed, the defendant that was defaulted says, aha, I got you on a technicality. You amended your pleadings, not as to me, but as to other people. Therefore, I get to start all over.
But it's not really whether they would have won on that motion. It's whether they presented an arguable or justiciable issue. Was it frivolous? Didn't they have a good faith basis to at least bring that issue up? And ask
you're talking about the motion to dismiss, Your Honor?
Or the motion for leave to file a responsive pleading to the second amended complaint?
I don't believe they do, because it all hinges on the position, the foundational point of view that the judge has sanctioned their client for, y'all make the call whether it's egregious conduct or not. But I think when you give false testimony under oath about the salient issues of the case, it's pretty egregious. So the court enters that sanction, and because you amend the complaint, they get to say, hey, we get to do all this over again. And really what happened before doesn't matter. I think that's would really hamstring trial judges to deal with misconduct of litigants.
Counsel, I'm going to ask you to address the opposing party's concerns about the notice and opportunity to be heard. Since the trial court in this case indicated she was operating under her own initiative as opposed to the motion, do you think that there is a due process issue here?
I don't. And if you go to page 20 of our brief, you'll see the actual quoted soliloquy between the trial court, Mr. Anger, and Mr. Anger's partner about, we're at the hearing. They've raised the issue of how we noticed the hearing. And the judge actually asks him, well, and I'm paraphrasing a little bit here, but she asked him, are you prepared to go forward? And on 2 occasions, they indicate that they're prepared to go forward. But
their argument is not, I don't think, so much that they weren't prepared for your motion as they were not prepared to address the judge's concerns since she sanctioned on her own initiative as opposed to your motion, and that they should have been, I guess, forewarned that the court was considering sanctions on its own initiative.
Right.
How would you
The-
respond to that?
I would respond that this court's opinion in HFC Collection Center adopted the reasoning of the Coke Court from the 2nd District, and I think make very clear that that 21-day notice is not required. I would also argue that nowhere in any of the appellate's briefs have they proffered what exactly it was that they were denied the ability to present to the court.
Isn't the problem there, counsel, that if the trial judge says, I'm sanctioning you for some reasons, and some of them are contained in your pretty broadly written motion for sanctions, basically, hey, you should know to stop litigating this case, and some of them are mysterious, some of them are out on their own. If they don't know what those reasons are, how do we know that the judge's concerns couldn't be solved with a simple evidentiary hearing to disprove whatever the judge was not sharing? In other words, to me, that would be the due process concern.
I read the brief and I see what y'all seem to be concerned about with Mr. Anger is these sort of, well, was there a secret reason that's not articulated by the trial court? I have no way to, I don't know. All I know is what was said at the hearing. All I know is what we argued. All I know is what the trial judge ruled. So I don't think it's fair to speculate about what a trial court may or may not have been thinking that's not put in their order. And that seems to be the subtle, there was another reason other than what she put in their order. And I think that's not, I don't think we should go there.
But then what do we make of that sentence? I'm not simply adopting the reasons set forth in the motions. I mean, that could mean three things. It could mean I'm only accepting what's going on in the motions. I'm not accepting anything that's going on in the motions, which seems to be discounted because of her other factual findings in the order. Or the third option, which there's a mix of the two. If there's a mix of the two, doesn't a party have a due process right to effectively answer that allegation before they're made to pay the toll for it?
I'll answer it this way, and it's the best I can do. We had a trial judge here that wasn't somebody took over the case from somebody else. She was intimately familiar with the pleadings, the process, the procedure in the case. She was the actual trial judge that took testimony at the hearing and knows what happened. She knows the follow-up motions for reconsideration. She knows about that. She knows the record. There's not some other judge looking at the record. So she has that. And I don't think she should be faulted for saying, I know what the record is. That's number one. Number two, I don't read the cases the way my opponent does, and that it says that a trial judge can't, because the proponent of the motions for sanction says, here's the reasons we think you should be sanctioned. That means that a trial judge on their own initiative has to say, okay, I know what the proponent said, 1 through 10 are the reasons for sanctions. I can't do those because the proponent argued them. I have to come up with unique ones, 1 through 10 or 2 or 1 through 3, however many she finds. I have to come up with the unique stuff. That seems tough because she's actually sitting there listening to the evidence and she knows it in the scheme of what actually happened in this case. All the different lawyers, all the different motions, the pleadings, she knows all this stuff. And so I think the court on her own motion can independently say, I hear this evidence that the proponents made. It seems absurd to me to ask a trial judge to act like they've got blinders on to what actually happened and saw. That doesn't seem to me to promote justice, and ask them to do it that way and say, now we need to independently come up with something. So I don't read the cases as requiring a trial judge to do that. It doesn't seem to me to make sense. Did I answer your question fairly? Sometimes I wonder. So anyway, in this case, I got 43 seconds left. The standard being advanced by the appellants here is that it seems to be technical, put form over substance. They've not proffered how they were injured. They haven't proffered what evidence they may have put on, not to Judge Herndon, not to this court. They've made representations to the court at the beginning of the hearing that they were prepared to go. Had they said, we're not prepared to go, it wasn't properly noticed, I'm fairly confident that Judge Herndon, given the back and forth about that issue that's in our brief, would have said, okay, properly notice it, we'll come back later and have a hearing. You have to deal, I'm not accusing anybody of not having candor with the court. It may have been accidental, but you have a duty to tell the court exactly what you're thinking. And if you're not prepared,
Counsel, your time is up. If you just want to wrap that up.
that's it. You have a duty to tell the court exactly what you're thinking, and so that they can make appropriate rulings like, okay, we'll continue this matter and take it up at a later date. Thank you so much, Your Honor.
Thank you.
Thank you, Your Honor. I'd like to start off by briefly revisiting the question that Judge Traver presented to me before I had to rest for Mr. Gilligan. And that is that I would disagree with the assertion that we were re-injecting ourselves when we filed these motions. With respect to the motion dismissed, the sanction was a default. And strictly speaking, a default only provides liability to the allegations that are well pled. And if the well pled allegations don't support a cause of action, the count's due to be dismissed. And that's all that we argued in that regard. And we don't think that the way in which the sanction came about matters once a default is entered. Once a default is entered, we think technical rules of default law apply. That's very clear based on the ICMFG case, where notwithstanding the fact that a default was entered as a sanction, the party was allowed to contest damages and causality as it normally would had the default been entered any other way. With respect to the motion for leave, I disagree that we were re-injecting ourselves. We were simply, for lack of better phrasing, taking advantage of facts that were created after the entry of the default that didn't have to be created. Mr. Gilligan and Strickland made the decision to voluntarily amend their complaint after they got the benefit of default. They did not have to do that. But by doing so, we believe that they opened a door to an argument that they had waived their right to continue to rely on the default. And with respect to the motion for reconsideration, I suppose of all the motions, that might be the closest to saying that we were trying to re-inject ourselves into the issue. But in that regard, we think that we had ample reason to do so. And more fundamentally, there's no Florida law that says we couldn't do so. There's been a lot of talk about due process in this case today. And while we think that there are fundamental due process errors, we would state that our primary position is that the court does not even need to address the due process errors, because fundamentally, Florida law permitted the appellants to do what they did below. And Strickland has not been able to identify any case law that says we couldn't do what we did below. To address, so I see I'm running out of time. And so we would respectfully request that the trial court's order be reversed. And we don't think there's any need to remand for further proceedings, or otherwise we would ask that it be reversed and remanded to address the due process errors. Thank you for your time and consideration.
Thank you. Thank you both.
Thank you.